Welcome everybody to today's webinar, Evictions Amid a Pandemic, Understand Your Rights. Here's what we're going to talk about today. We're going to talk about how does the eviction process work, what are rent control statutes, eviction moratoria on the state and federal level, how does bankruptcy muddy up the waters. We're going to talk about tricks of the trade, and then at the end we're going to have questions and answers. Okay, so what we're going to do today, just because we have a national audience, we're going to talk about the jurisdictions that I'm admitted to practice in, which is New York, Florida, and Texas. And please, if you just joined, please mute your microphones. And we're also going to talk about some other jurisdictions that are highly populated. We're going to talk about the eviction process in New York, in Texas, in Florida, and Illinois. So when we talk about the eviction process, what are we talking about? We're talking about the situation where a landlord is seeking possession of the property. So we'll contrast that because we're going to talk about that a little later when we discuss different alternative methods to obtain possession, as well as if a landlord is suing you for past due rent. In that situation, what we're going to talk about right now does not apply. What applies is what we're going to talk about right now. So basically, when we're talking about a situation where landlord is seeking possession of the property, we're talking about a tenant has defaulted either by payment or another requirement under the lease. And under this situation, state statutes require a notice of default. So for example, in Florida, where I am sitting today, it requires a 3-day notice before you can file an eviction proceeding, and if it's a 7-day notice in the event of another default under the lease. In New York, it requires a 14-day notice demand for rent, and if we're talking about a non-payment default, it requires a 30-day demand. In California, they require a 3-day notice for non-payment and a 3-day notice for other defaults. In Texas, where I'm also licensed, it requires a 3-day notice for non-payment and a 3-day notice for other defaults. Illinois, which is the other populous state in the U.S. that we're going to discuss, Illinois has a 5-day notice for non-payment and a 10-day notice for other defaults. If you're attending this webinar in another jurisdiction, please you can ask a question about your particular jurisdiction in the chat function, or if you're watching this on our YouTube channel, you can ask your question in the comment section of the video, and we're more than happy to respond back to you with an answer to your question. So just to sum it up, before you can file a lawsuit for possession of your property, each of these states and all 50 states have requirements that you serve a notice of default or cure on the tenant before you're allowed to, under state statute, to file your eviction proceeding. So evictions generally utilize summary procedure in most states. And what I mean by summary procedure is in many states, when you are filing a lawsuit and you are seeking to answer, you're seeking your other party to answer or respond to your lawsuit, the general time frame is anywhere from 20 days, for example, in Florida, 30 days to 45 days in many other jurisdictions. So the time starts for the tenant to respond from the date of service. Now, one of the difficult processes is to actually obtain service of process over a tenant. The most ideal circumstance is personal service. So a process server, a sheriff, a constable, will go to the resident or go to the tenant's place of business and physically serve them with a copy of the lawsuit and the summons. And in many jurisdictions, it will also include when the court date for the tenant to appear to respond to the petition or the complaint for possession. Now, oftentimes, for those of us that are experienced in this area, there's always a challenge when you have to respond to these lawsuits. And the key is the court will not deem a proper response unless there's proper service of process over the tenant. And how you achieve that, as I mentioned, the most ideal scenario is that you obtain personal service. Now, many tenants won't answer the door, won't respond, even if there's a sheriff knocking at their door. So there's alternate ways to obtain service. The other way to obtain service is substitute service, is when you serve a copy of the complaint and the court date and the summons to another adult that's over the age of 18 that lives in the household. Now, oftentimes the tenants will specifically direct anyone living in the property not to answer the door. So there's always the last process is the alternative service. For example, in the state of Florida, we call it nail and mail. So what happens is you post a copy of the lawsuit, the summons, and the court date, if applicable, on the residence, and then you mail a copy of everything, first class mail, to the last known property address, which would be the subject property address. And then also you have to file a certification with the clerk of the court, and the clerk of the court will certify mailing of the process as well. So that's the alternative service. So whatever process service occurs, whenever that service occurs, then the process server will file an affidavit of service with the clerk of the court, and that's the date the clock starts ticking. So now going through this, I'm listing what the time frame is for particular tenants to respond. So for example, in Florida, where my office is located and when I practice mostly, tenants have 5 days from service of the complaint for possession to respond. Now, Florida is a state where it does not automatically require a hearing for evictions. So most of the time when we handle evictions for clients, it's rare that we'll go to court unless it's contested. So as I show in the next sub-bullet point, a court hearing is only required if a tenant files a response. And if it's a case for non-payment, the tenant has to deposit the past due rent in the court registry. And this creates, especially during the pandemic, when the courts are still closed for the most part to the general public, this creates many issues. And so, for example, right now, and we're going to talk about it in a little later, there are a variety of moratorium in a variety of states. Florida, we are currently under a residential eviction moratorium, which we're going to talk about a little later in the webinar. But simply put, there's a lot of complications right now for a tenant to even comply. And this really muddies up the process and makes it even more difficult for tenants to comply, and also for landlords to get their complaints for possession pushed through. Now moving on to New York, and before we move on to New York, one other issue is like one common question that we have: if a tenant, and we occasionally do represent tenants in the eviction process if we feel they have a bona fide defense in the case. So for example, if there's a situation where the amount of rent is in dispute, the statute requires that you deposit the entire amount of rent in the court registry. Now, generally, the process to obtain what the correct amount of rent is called a rent determination hearing. And you are able to accomplish this by filing a motion in the court. And we're going to talk about that a little later on in the process as well. So moving on to New York, in the state of New York, it requires a court appearance, and a court date is included in the documents served on the tenant. And service must be 10 days prior to the court date. So for example, if you're the landlord and your process server serves the tenant 9 days prior to the hearing, the court is going to automatically adjourn a hearing to the next date. And New York, just like Florida, has a alternative process, which they also employ mail-in mail as well. But what I can tell you is that judges in New York, right now, in New York is also under an eviction moratorium. And for example, if you have properties in the 5 boroughs of New York, in New York City, the housing courts, and these cases go to the housing court, they are extremely busy. Now in Florida, we only have 2 types of courts. We have county court and circuit court for civil matters. And all evictions will go to county court. Moving on to California, the tenants have 5 business days to respond to the complaint for non-payment and 10 days for other defaults. And just like Florida, California does not have an automatic requirement to obtain a court appearance. So New York and Florida don't require court appearances unless there's defenses provided or a landlord requests a court appearance. But the other 2 states, Texas and Illinois, they both require court appearances. And in Texas, you will go in front of a justice of the peace. And Illinois has special housing courts, especially in Chicago. Like New York, they have special housing courts. And in Illinois, a court appearance is between 7 to 40 days, and the tenant must be served at least 3 days before hearing. And again, just like New York, if you're served less than the statutory time period, the judge will automatically adjourn your case until the next hearing. And at the court appearance, there's generally not multiple court appearances because we're under summary procedure, unless there's a motion or some other requirement under the law that requires it. But at the court appearance, the judge makes an evidentiary determination whether or not the tenant must be evicted. Now, because these are lower level courts, all of these courts are not the highest court, trial level court in the state. Every jurisdiction that we mentioned above also have a right of appeal. And so, for example, in Florida, you would appeal to the circuit court, and New York, California, and Texas and Illinois, you would appeal to the next highest court. And generally, if the appeal is timely filed, a tenant will not be required to be evicted while an appeal is pending. Now, landlords, depending upon the circumstances, they may require that a tenant post an appeal bond. And if the court requires that a tenant post an appeals bond, then basically the tenant will not be able to, will be evicted because the cost of an appeals bond is extremely cost prohibitive. And generally what we've seen is most tenants, if they aren't able to pay their normal rent, they're definitely not able to pay the cost of an appeals bond. And then at the court appearance, if the judge rules in favor of the landlord, the judge will sign a final judgment, and then ultimately they will have the clerk of the court sign a writ of possession or writ of execution. And this particular process is the key because in Florida, until August 1st of 2020, there is a prohibition on residential writs of possession. And in many other states, the entire process is stayed. In Florida, landlords can file eviction proceedings. Now, not every clerk of the court will process them, but the clerks of the court in Palm Beach, Broward, and Miami-Dade County, which is the area where I primarily practice, they are actively accepting and filing these eviction proceedings. Now, individual judges have their own requirements, and I will caution you, because many judges, especially in South Florida, where we are one of the epicenters of the COVID-19 pandemic, they are not processing residential evictions, and many judges, including many judges in Palm Beach and Broward County, they are not even processing commercial evictions as well. So just keep that in mind, because the process is you go to the court appearance. If the judge rules in favor of the landlord, then the judge will sign the final judgment. And in the final judgment, it will authorize the clerk to file the writ of possession or writ of execution, depending upon which state you're in. And now the final step is that once the writ of execution or the writ of possession is issued, then the sheriff is going to serve the writ on the tenant. And generally in most states, depending upon states, like for example in Florida, once the sheriff serves the writ of possession, you have 24 hours to vacate the premises. And then depending upon the state statute, if any property is left over, each particular state governs how long what to do with the excess property. Like for example, in Florida, if you leave any property in the property after the writ of possession is executed upon, then that property is deemed abandoned and it becomes the property of the landlord. So pretty draconian steps. So just keep all of that in mind, when you're evaluating everything. And we're going to talk later how bankruptcy throws a wrench into everything. So earlier throughout this presentation up until now, we were talking about a complaint for possession. Now it's important to contrast this between past due rent payments. So many times, not only is a landlord seeking possession of the premises, but they are also seeking past due rent payments. And if they are, then it's a separate procedure. And so sometimes landlords will file them together, but a lawsuit seeking past due rent payments follows the standard civil procedure. So for example, it would be 20 days to 45 days, depending upon the state. And now, for example, if we're talking about a past due rent lawsuit in Florida, if the amount of rent is under $8,000, then that will follow small claims procedure. And instead of a requirement that a tenant has to answer the lawsuit like in a standard civil procedure, they will actually get a date for a pretrial hearing. And at that time, they don't have to file any written answer in the case. They can defend their case by attending the pretrial conference. And then also during that time frame, they will also be ordered to go to mediation. And that's a requirement in Florida. Now, depending if you're listening to this in other states, the general process is that if it's under a certain dollar amount, it'll go to small claims court and they will get a hearing date. And if it's over a certain dollar amount, then they will answer a lawsuit under any other time frame. Now, many states don't allow cases to be bifurcated. What I mean is splitting them up between the summary proceeding, which would be the complaint for eviction or possession of the property, and the procedure for collecting past due rent. Now, what we do is we recommend our clients first file the lawsuit for eviction and then later file the suit seeking non-payment of rent. The only downside to that, the upside is that we will be under summary proceeding and the case will move a lot quicker. The downside to it is they do have to pay 2 separate filing fees and 2 separate service costs. Now, I will note a lot of my clients, what they do, especially if we're talking about a larger apartment complex, what they will do is many collection agencies and law firms handle these types of matters on a flat fee basis or a percentage basis, like a contingency fee basis. So, generally, if you're having an attorney file these lawsuits, unless they're large dollar amounts, it's generally better to have a collection agency or for the landlord to file these themselves. And in Florida, a corporation or any type of entity can represent themselves in small claims court, provided it qualifies for small claims court. Any past due rent over $8,000, though, you're outside of the jurisdiction of small claims court. And under that scenario, an entity must be represented by counsel. An entity must be represented by counsel unless we are talking about a situation where it qualifies under small claims jurisdiction. So now, up until now, we were talking about a tenant under a current lease or under a current tenancy that was past due on rent or violating another provision of the lease. Now, there's another way that you can get tenants out of the property quicker, and the way to do it is to terminate a month-to-month tenancy. In Florida, month-to-month leases are terminated by providing 15 days notice, provided such termination occurs at least 15 days before the end of the month. So for example, if we wanted to terminate a month-to-month tenancy for July, since the date of this webinar is July 6, 2020, you would be able to provide 15 days notice to the tenants if you serve them with the notice prior to July 15th of this month. If, for example, you provided them notice on July 18th, then they would have until August 31st, 2020 to vacate the property. Now, New York and other states have much longer time frames to terminate month-to-month tenancies. In New York, if there's less than a year left on, if the tenant has occupied the property less than 1 year, then they can be terminated by at least 30 days notice. If it's more than 1 year but less than 2 years, it's 60-day notice. And if it's more than 2 years, it can be terminated by 90 days notice. Now in California, if it's less than 1 year, you have to give them 30 days notice to terminate the month-to-month tenancy. And if it's more than 1 year, it's 60 days notice to terminate. In Texas, it's a standard 30 days notice before terminating month-to-month tenancy. And in Illinois, it's 30 days notice is required before terminating. Now, before we jump into the eviction moratorium on the federal side and the state side, I want to talk briefly about bankruptcy. So under bankruptcy laws, if a tenant files bankruptcy and they are a residential tenant or a commercial tenant, all the automatic stay goes into effect under section 363 of the under section 362 of the Bankruptcy Code. And under section 362 of the Bankruptcy Code, provided that a writ of possession has not been issued by the clerk of the court, then all eviction proceedings must stop. And in a residential tenancy, if the tenant who's a debtor in bankruptcy is filing a Chapter 13 bankruptcy, they actually can, in their Chapter 13 bankruptcy plan, they can catch up on the past due rent, provided they continue to make the current rent payments to the landlord. They can catch up the past due rent over a 5-year period, which is pretty amazing. Now, as a landlord, what you are required to do is you can actually file a motion for relief from stay with the bankruptcy court, which in essence gets the bankruptcy's permission to lift the automatic stay in bankruptcy court and transfer the case back to state court and continue to process the eviction case in state court. Now, the key is, if, for example, a writ of possession has already been issued by the state court, the automatic stay is not in effect, and the landlord can continue to proceed in state court. However, I will caution you, because the sheriff who is going to be executing the writ of possession, they generally will not execute on the writ of possession unless there's an order from the bankruptcy court. So either way, a landlord's going to have to seek bankruptcy court approval to transition the case back to state court. Now, bankruptcy is a whole other beast, and we are going to have a future webinar on the methods that bankruptcy affects real estate. So stay tuned for that. So now jumping into it, there is both federal and state moratorium on evictions currently, and it depending upon what the property type is, that will necessitate whether or not what type of eviction moratorium you're under and the length of it. So for example, if the tenant resides in a property that's part of a government program or has federally backed loans, for example, HUD loans or Section 8 tenants, then the eviction moratorium has been extended to August 31, 2020. And most state courts, including Florida, Texas, New York, California, and Illinois, require that a landlord fills out a COVID-19 affidavit, which certifies that this particular eviction is not subject to any of the CARES Act federal moratoria. So if the particular property falls under the first bullet point, then the court will not even allow a processing of the eviction, and an eviction case cannot be filed before August 31, 2020. Also, if the property is a single family home, townhome, or condominium where the landlord has a federally insured loan, an FHA loan, then this eviction has also been postponed until August 31, 2020. Similarly, if the landlord has a Freddie Mac or Fannie Mae loan, which applies to single family homes, townhomes, or condominiums, the date evictions can commence also is August 31, 2020. So let's assume that you have a small apartment building that doesn't apply to any of these. Then we have to, the next step is we have to check to see if we're under any state court or state law moratorium. So in Florida, assuming that you weren't subject to any of those prior limitations, in Florida courts cannot issue a writ of possession until August 1, 2020. So what does that mean? It means that a landlord can file an eviction proceeding. They can proceed to final judgment, but the clerk of the court will not issue a writ of possession. So what I can tell you in practice is most Florida courts aren't even moving any of these cases along that fall under these complaints for possession. And certain judges have put out orders or directions that say they will not process any of these until the state moratorium is lifted. Similarly, California Governor Newsom has signed an order allowing individual counties the ability to prohibit residential evictions until September 30th, 2020. And what I can tell you is that the major counties in California have already issued these prohibitions on residential evictions until September 30, 2020. In New York, all eviction cases, both residential and commercial, have been adjourned until August 20, 2020. Now, there's no prohibition against filing these cases. Now, individual courts and individual judges may prohibit. And I know, for example, in New York City, the housing courts are not accepting any eviction cases right now. But in essence, eviction cases will not start moving again until August 20, 2020. In Texas, there is no state moratorium anymore, but local governments have certain moratorium in place. Like, for example, in the cities of Dallas, Dallas County, Austin, in Travis County, the city of Houston, they all have certain moratorium. And interestingly enough, what we're going to talk about in the next slide is there is some other methods that landlords can get paid, and we'll talk about that momentarily. In Illinois, the eviction moratorium is until July 31, 2020. Now let's shift gears. Also, certain states have rent controls. Florida has no rent control statutes, and rent control basically limits the amount of rent that can go up on an annual basis. And that's in essence what a rent control or rent stabilization means. New York has very pervasive rent control and rent stabilization laws. Rent control is that if a tenant has lived in a property since 1971 and the building was built before 1947, they're paying 1970 rents. And these are the crown jewel in New York. And if a tenant changes, then the rent control no longer applies. So the only way to really obtain a rent control property is if a relative or a spouse, an heir of some sort, has a rent control. And that's the only way that you're able to obtain those. Now, rent stabilization limits the amount a landlord can increase on an annual basis. And so these rent control, these rent stabilizations, there's a list. The state of New York has a list of these rent stabilization buildings. Now in California, they are the only state to have a statewide rent control statute. And in California, landlords cannot increase rents more than 5% plus local rate of inflation per year. So there is a limit in California for you investors out there to really lease up a property to market rents. If you inherit a property with below market rents, there's a limit on what you can increase. Texas has, like Florida, has no rent control statutes. And Illinois, interestingly enough, has a statute that prohibits municipalities from instituting rent controls. So Chicago is one of the few major metropolitan areas that do not have some type of local rent control in place. Now, here's some tricks of a trade. So right now, as a landlord or investor, you are under some major obstacles to evict tenants for non-payment. So here's some tricks of the trade. Probably the best way to get a non-paying tenant out of your property is basically provide them a cash payment so that they will leave the property earlier. And that's called cash for keys. And that terminology was quite popular during the foreclosure crisis when lenders were providing foreclosed homeowners some moving money. And that would be the best scenario. Another scenario would be that you enter into a settlement agreement with a tenant where you waive past due rent if a tenant vacates the property. Now, if the lease has been terminated, you could also alternatively sue for ejectment instead of eviction. Now, that basically is a situation where you're suing a tenant for trespass, and it's governed by the standard 20-day process. And the key is consult an attorney in your state about this in particular. Now, another scenario would be your direct tenants to municipal or state funds available to tenants. Through the CARES Act, the federal government has provided states and municipalities funds to provide to tenants that are behind on their rent payments. And particular municipalities, like for example, the city of Dallas, Austin, a lot of the city of New York. From what I hear, some rumors that Florida may have some funds available to tenants to credit them or provide them some subsidies for rent payments. And ultimately, as a landlord or as a tenant, you want to take advantage of these funds. Now, there are also certain municipal and states that offer funds to landlords whose tenants have not paid rent. And those, again, are situations where you have to be the first in line as soon as it opens for you to take advantage of it. And then the last scenario, if you're a landlord, is seek a forbearance with your lender so that you can survive during this process of moratorium. Now I'm going to jump into questions. Please enter your question into the chat box and I will answer your questions. Okay, the first question is, we have a property in escrow. The tenants are refusing to move, claiming cover. The tenants are undocumented workers. They will not sign anything and they will not identify themselves. The loan is a Chase-owned loan, so federal cases don't apply. The courts are closed due to COVID. We want possession. The tenants are refusing to pay. Now, what I will tell you though, even though it's a Chase-owned loan, it very well may be a Fannie Mae or Freddie Mac loan. If it's a Chase portfolio loan, then you're correct that the Federal CARES Act does not apply. What I can tell you is, unfortunately, and I don't know what state you're in, but if you were in one of those states that have an eviction moratorium, you're really just going to have to wait until the moratoriums are lifted, or use one of my other tactics or tricks of the trade that I mentioned to you. Will my presentation include info about going to mediation? Generally, what happens is when you file an eviction case, then generally you will be required to go to mediation if you go to a court hearing. Okay, next question. Okay, Florida does require a court appearance. Sorry, California does not require a court appearance, and you're using the technique that we discussed earlier. You do want to give 60 days notice because the property sold. You generally, the best thing to do is waive past due rent, and ideally, if you can get that tenant to sign it, that would be the best situation. Last question we have is, do you think there'll be a force majeure clause added in the lease? If it specifically does not provide for it, then you do not have the benefit of taking advantage of force majeure. Now, there's always an argument that if we're under a moratorium, then you are subject to a force majeure by statute, but that certainly, unless it's particularly in the lease, I'm not sure you can take advantage of it. Well, those are all the questions that we have today. And again, you have my information. You can reach out to me at wallacelawoneme.com. You can visit our YouTube channel at the Wallace Law Group, or you can visit our website at thewallacelawgroup.com. Thank you.